let us get into Young Thug. Y'all know there's been some situations going on when it comes to his attorney, and we are about to check that out. And we got to get into this mess because I feel like it's some corruption or something going on. So let's check it out.
Yourselves cross purpose. You all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you.
No, 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 no. That's not the one I want to pull up yet. Okay, that is not the one I want to pull up yet. For the people that do not know, Young Thug's attorney was indeed arrested. Okay, he pretty much had some tea that he was not willing to share with the judge. Okay, and the judge had him arrested. So let me see. I wanted to pull up. Is this it? Okay, yeah. I think this might be. We'll get into this one here. All right. Is this it? No, I want the news story. I wanted the news story, but they're not giving us the news story. So, basically, things got heated during the YSL RICO trial after an attorney of rapper Young Thug was taken into custody. In court on Monday, attorney Brian Steele was held in contempt of court by Judge Earl Glanville after refusing to disclose his source regarding information shared in an ex parte meeting. Okay. Now, I cannot say whether or not Young Thug has committed the crimes that he has committed. And I hate to say it, y'all, I don't really care. But what I will say is that this judge was out of motherfucking line. I do believe that. So we're going to listen to how all of this stuff really broke down when it comes to the judge and the attorney. And I'm definitely on the attorney side with this, but I'll let the actual attorneys leave their thoughts on whether or not they feel like the judge acted in the proper manner or not.
He is. He's right behind you. All right, you can make it right now. Is he out? Where, is Mr. Copeland out? No, he's in. Okay, good. All right.
He finna gag the hell out of the man.
Thank you.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told, based upon information and belief, that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me that never.
Mr. Steele, can I interrupt you just a second?
What would you
I'm
like?
kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too, and the reason
Well, I'm asking you a question.
and I'm
How
gonna
did you
answer
find
your
out
question.
about it?
I'm going to answer.
Y'all see this? He's more upset about not so much as the conversation that was being had, but more so about how he found out about it. Right out the gate, I feel like you wrong. The man is supposed to be a part of those conversations. Why are you pulling a witness in with a conversation with you and the prosecution? And it's the prosecution's witness. That's given very sketchy. And then it's crazy about how long this trial has been going on. I feel like the damn trial about been going on for about a year. I don't know. Maybe I'm confusing it with what YNW Melly, because it's been on trial, and like it's just a whole lot of damn going on. I did hear that the prosecution team has a ton of witnesses, and maybe that's what's dragging out. But this judge is not to be trusted, is what it's giving. And I feel like the judge and this attorney may have had some back and forth previously anyway. But yeah, the judge is pressed. That man said he is disturbed, okay? That man said he is disturbed at how you got this information, and I'm asking you how you got it, okay? I'm not going to tell you that, sir. I want you to hear that's not the matter at hand. How I got it ain't the issue. It's the fact that it happened. And that's what you need to be focusing on, because you're operating unethically. Okay? That's what we need to be talking about.
To the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those were ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward.
You noting it for purposes of record because you don't know what else the fuck your ass said, and you also don't know what else the fuck he knows about your ass either. Okay?
What I was
Make a note.
told was that Mr. Copeland said.
And you haven't answered my question yet.
I'm not going to.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get
No.
anybody else.
I'm asking
Listen,
you, how did you get this information?
This man is giving. I'm not answering your question because I'm here to expose you, not expose my source. That's what we're here for. We're here to expose you, sir, not my source.
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversations with a party. I mean,
A
witness,
who was
fool.
sworn in Friday?
Thank you.
The court.
Thank you, sir. He told me something a party. That's what you trying to do. You trying to finesse this man. Like he ain't studied the same law that you done sat up here and studied. He just ain't no judge, sir. You trying to play in this man's face, talk about a damn party when you knew this witness had been sworn in. You knew you was out of line, and you knew that man was supposed to be in that room when y'all had that conversation. Girl, he finna eat.
Tell him, this is what I was told. If it's not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is.
We need to go forward because I feel like your credibility, your position on this case is now becoming in question to where I hope they try and get you removed off the case, sir. Okay? So that's what you need to be focused on, but you're more focused on how he got the information. Absolutely not.
This. I was told, and I hope this concerns the court.
It
I was
concerns
told-
me that you have proprietary information.
Why is it
or
proprietary?
information that
thinking
you
the
should
same
not be
thing.
having that was ex parte
Why?
with a party,
Why?
state of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly
That's
this honorable court,
okay.
or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele,
I'm
I
doing
still
what
want to
everybody
know,
should
how
do.
did you
I know that's right,
come
sir.
upon this
Come on, Mr.
information?
Steele.
Who told you?
What I want to know is why wasn't I there?
Ooh.
Sir, I'm going to hold you in contempt if you don't tell me who this
Wait, now hold me, Your Honor. Hold me, okay? Because I feel like when it comes to the question of the court, I think that the attorney's question needs to be answered first. Then we could get to who heard, how they heard, or whatever. Because I feel like had things not been broken or violated to begin with, then you wouldn't even have the issue on the back end. See, y'all operated out of order to begin with, so we need to address that first. In my personal, but baby, I don't know. He probably got a listening device, and maybe the witness that's working for y'all probably working for him. Girl, this is messy.
I
Tell me who this information
don't
was
want to
come
be
from.
held in contempt.
Well,
I'm not
then-
answering that question. That's attorney-client privilege information. I am not answering that.
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
I am
I
telling
tell you
you-
what, I'm going to give you 5 minutes. If you don't tell me who
Don't
the
have to.
This
I'm
is
if
what-
you don't tell me who it is, I'm going to
This
put
is what pisses me off. You know what? It's the scrunching of the face and the pointing for me. Let me give you 5 minutes. Like, first of all, this is you trying to exercise your power now. Now you're trying to abuse your power up in this BITCH. Okay? And you better be mindful of how you operate, because right now, when I heard this on the news first, I said, now, wait a minute. Now, what? He over there having a conversation with the witness. I immediately thought, okay, that's not how this supposed to go. Okay? And I said, this judge better be very careful, because it seems like he's abusing his power. And let me tell you something. You better be careful and hope that if you got to be up for election of some sort, you better hope the people vote you back in. While you over there abusing your power, sir. Okay? So when I saw this video, I was like, okay, now I get to see more versus just a little, quick news clip that they gave, and I could really find out like what's happening, because this is my first time watching it with y'all.
I'm going to put you in contempt, because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
Ooh.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland made statements.
Yeah, you don't want nothing else on that record. That's why you trying to walk out. And the gag was, the whole time you was talking to this man, you was over here looking at the defense team. You was over here looking at them to see what their reactions are, and it's giving some slick stuff is giving in cahoots. Now, granted, I don't know what Young Thug has done, and like I told y'all, I honestly don't care if he get locked up, he don't, oops, whatever. But at the same time, like, that's not how that's supposed to go, sir. And you looking over here at these people, because y'all got some things going on.
That he admitted to killing Donovan Thomas and was. Don't take my notes. No.
Ooh.
Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No. I have a.
He is. He's right behind you.
Sorry, I have a motion that I need to make outside the presence of Mr. Copeland.
All right, you can make it right now. Is he out?
Is this the repeat? I hope this ain't a repeat. Okay, I
good.
think this
All right.
may be a repeat. Yeah, I think this is a repeat. Listen, I'm here for this. The judge got up and walked the hell out. But what happened was the judge did sentence him. Let me see if they show that though. If they let me see.
Witness. How about Mr. Copeland, who supposedly announced He's not testifying.
Okay, yeah,
and
they
he'll
don't
sit
have it on that. Let me see, because I want to find the news story because they ended up sentencing this man to what 20 days, and his wife happens to be an attorney as well, and she is filing for an appeal for her husband. Okay, well, this is some messy stuff here. Let's see. Okay, we can get into this one here. All right.
Tonight, a judge ordered Young Thug's lead attorney to spend the next 10 weekends in jail.
That's right, and they say it's because of a secret meeting between the judge, prosecutors, and a star witness. Channel 2's Brian Mims tells us the attorney refuses to say how he found out about it.
That's attorney-client privilege information. I am not
Attorney-client privilege, unless you were in my chambers, that's the only way you can figure out.
The attorney for Young Thug had a long, heated exchange with Judge Euro Glenville. The judge gave Brian Steele 5 minutes to disclose where he learned of the meeting in the judge's chambers with prosecutors. At issue is this star witness for the state, Kenneth Copeland. He spent the weekend in jail after refusing to testify on Friday. Copeland reluctantly took the stand today, but dodged many questions. After a lunch break, Steele said he learned that prosecutors allegedly told Copeland that he could be in jail for the duration of the trial, and even until all 26 defendants have their cases disposed of. Steele said, if true, that's coercion and witness intimidation. Young Thug's other attorney, Keith Adams, said if Steele is removed, he could not continue with the proceedings.
Okay, and the challenge
Mistrial.
I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that.
He glossing over it the same way your ass was glossing over the fact that it even happened, sir.
In its entirety.
Brian Mims, WSB Tonight.
Steele's wife, who is also an attorney, filed an appeal. She's asking that he be released on bond while the appeal is decided. Meanwhile, the judge released Kenneth Copeland tonight, but he must testify tomorrow. Now, Steele is not the first lawyer in this case to face charges. In February, police arrested defense attorney Nicole Fagan.
Oh,
They said she killed
yeah.
a suspect in a separate gang case to hide evidence. Then last May, a different defense lawyer got arrested when he brought his prescription pills into court. He avoided jail time by buying lunch for the other lawyers from a strip club. Then, in August, a judge seized a lawyer's laptop that police say a defendant was using to buy contraband from a deputy.
I have been part of a big.
Y'all got all kind of stuff going on with you, Judge Ural, or whoever the hell you is. Your Honor Glanville. I don't know what y'all got going on over there, honey, but y'all gonna have to shift it, change it, rearrange some of them seats over there. Okay. Now I want to go look into the other attorneys and see what this lady talking about, to see what had happened with these folks and why they had got arrested. So many attorneys getting arrested. My God. Well, listen, I'm standing on the side of Young Thug's attorney 100%, and that's really what it's given. Okay, that man said he was standing on all 10s. He ain't giving no information, and I don't even blame that man. And then I believe he asked him. First of all, there was a video where I saw the man telling the judge, like, listen, you're violating my client's constitutional right to have representation because you're locking me up. And I, basically, I don't agree with this. I don't support this. I don't agree with this, or none of that. Is this where he throws him in jail? Let me see. So wait a minute. Let's get inside.
Okay, Mr. Steele, would you take the podium, please, sir?
Shit, now.
All right.
Is this the same thing?
All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia rule professional conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have.
Ooh.
1.6.
I know
Lies.
what the rule says, but here's the thing.
Well, let me just- let me just tell you Interrupt.
you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't,
He is so pressed about how he got this information, baby. It got me wondering what else is the judge over there hiding.
tell me how you got the information, I'm going to hold you in contempt.
I understand, and I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah, and that's why I raised it. It is that serious that we should have been there, and it shouldn't have happened.
Sir, that's a whole separate issue, and that's why
is the issue.
ex parte conversations are recorded.
Why would it be ex parte? You're
For
acting like
what-
it's
for-
ex parte under
It's
seal.
ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
And a witness. That's what you
Sir,
keep overlooking.
You're straying off
purpose.
the issue.
I'm not.
No,
The
you
issue
are.
The issue is, how did you get this information?
I understand the issue.
You keep
promise I
asking and
understand
he
it.
ain't.
But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
It sounds like that is what you did, sir. It sounds like you violated something and now you're using your privilege and your power, sir.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're saying,
see,
you're threatening me with
the
contempt.
privilege
Just listen
would
to it.
occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not sum and substance, but I'm telling you I can't do that under the bar rule.
All right. Well, I'm going to hold you in contempt, and you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
I can't do that.
Yes, you can, because I have an idea how you got it.
Well, then,
your idea-
stand
I have
on
an idea how
that.
you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time, and I'm not going
Sir,
to breach that confidence.
I don't want to hold you in contempt, but this is that serious.
Judge,
You
I'm the one who raised it.
you cannot eavesdrop and get information that was not meant for you to hear at that particular point in
Don't you,
time.
Judge, listen, and listen. I'll do whatever you want
No, I
to
wouldn't.
5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing, and I'm moving for a mistrial. It is my understanding, based upon information belief,
From
that
whom?
part of it.
From whom?
Well, I'd like to get the substance first.
You done
and then
laughed in this man's face. He
Okay,
finna send you to jail.
Then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
But you're assuming something because I told you already.
well then, other than
Answer
if
that
you were
under
sitting,
attorney-client.
unless you were sitting in there with a recorder or Miss Love or Miss Hilton or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor,
And if that person gave you that information or shared that information with you, she probably violated privilege.
well, let me tell you two things. One, I don't know how that is a privileged communication. It shouldn't have been.
Well,
ex
it's because
parte.
she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a.
When I got this information-
I'm not going to have any further conversation
Well-
with you about this. I want to
Okay.
know. The question still remains. I want to know who gave you the information.
I'd like to know what information happened outside our presence. That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your
Court
I'm going to deny your
becoming-
motion. I'm going to deny your motion.
I
for
understand that
mistrial.
you spoke with a
And when-
witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is
and
appropriate.
And you influenced the witness.
And
There's
that is
information
what
to
he's
believe, and
getting
I'd
at.
like to have that all in the record.
Yeah.
I mean, I don't know why that's so hard to do. If nothing
Okay.
happened bad, that's fine.
I know that's right. I know that is right. If nothing happened, then it should be no issue putting it on the record.
You're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, we can. That's for another day.
But why?
Okay,
Why
that's for
didn't we
another day.
exclude in the first place? I didn't know about this stuff.
That's
I raised
for
it
another
before the
day.
court.
So-
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2.
okay.
That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele,
private.
that is not that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication
Come on.
with
Come
a
on.
witness who's
Thank
been
you.
sworn.
This is what you
know,
keep
I'm not-
trying to
I'm not
overlook.
telling you, I'm just saying if you read I'm assuming you read it. That's what it says. And
This
you
judge
did it.
pissing me off.
The state wishes to be heard.
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is
State
why
does.
did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind
And
anything.
you can't hide behind, yeah, but the thing
You
is,
hide
I
behind
think
your
you got this
role.
information.
This is contradictory.
Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because
what
unless
I
you're
got-
sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information.
And you know what's crazy
So-
is telling him that he can't hide behind code 1.6, but you sitting over here hiding behind ex parte. Sir, everything that you're trying to put on him, you have to look at yourself first. In my personal, but you know,
Your Honor, but that's the
I ain't no
issue.
attorney.
Well,
Why aren't we
I'll
entitled to the-
that's
But isn't that the issue?
that needs to be told. But
But,
State, do you have
right
anything
now, we don't know
Mr. Steele.
why we were excluded from that.
Mr.
And I
Steele,
want that information
stop.
because
Just
Mr.
stop.
Williams' constitutional right on
Just
the
stop.
Georgia Constitution.
Just stop at this point in time, because
Article 1, Section
because
1, paragraph
you've
12.
already said
baby,
that.
you better repeat
You
them.
already
The
said
Georgia
that.
Constitution, and we have the right to be present.
All right,
And we're not waiving anything.
Yes.
Ooh,
Ma'am?
we ain't waiting
Ms.
for a
Love?
motherfucking thing. Come on, sir. Sir.
And Your Honor, excuse me. And I know I said this
She's
previously.
Yes, sir.
But we are not accepting any proffer
Oh,
from
gosh,
Ms.
okay,
Love.
excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained
Hurry up.
within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate, what he calls fact, and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a
Why?
matter
Involving a
regarding
witness.
a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach
But you do
out
sound
to
like
the state bar ourselves and ask
yeah, reach out to the state bar,
what the
girl.
appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of
I understand the
actions on
concern.
the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as I'm standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6.
I like how she kind of tried to flip that, and the way she took her time. I'm glad I fast forwarded her the way she was taking her time because she was trying to be very careful for what she said for the record purposes. But at the end of the day, it still sounds like you confirmed what Mr. Steele was saying the whole time about y'all having a side conversation with the witness because you didn't like how he was operating within the courtroom. So y'all took him back into the judge's chambers so that y'all can somewhat kind of blackmail him or intimidate him, as Mr. Steele said. Like, we need you to cooperate because if not, we're going to have you locked up for the next 2 years and you're going to be in here until all the other witnesses go and this, that, and the other. Like, that's kind of what it sounds like. Like, as careful as you were trying to be with your wording, to me, it did seem like you were confirming exactly what he said. Y'all pulled a witness in with the judge to intimidate him. So it sounds like y'all can have ex parte conversations outside, but after the witness had been sworn in, all members are supposed to be a part of that conversation, and that seems to be something that y'all may have violated according to him. But let's keep going.
If the court would allow me a moment.
All right.
I don't care about this moment now. Let's move on.
Appropriate remedies that we believe are available.
All right.
No, it
From the
is.
court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has 2 attorneys.
Okay, yeah, he does, but
The court, now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information we've received.
With how messy this case is, it should be a mistrial.
My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
Well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay.
Now, who coming up next?
8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who
So
was
is you the
meeting,
snitch?
what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark, and quite frankly, we kind of remain in the dark. I
Oh, bitch, let
am
me
not
rewind.
a false accuser, okay? I do not just willy-nilly.
I had to rewind this, man. Because if these
As
is
you know, I represent
thugs.
Shannon Stillwell. On behalf of Shannon Stillwell, I am
Okay.
going to be moving for a mistrial,
Ooh.
first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark, and quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things.
So messy.
So, I'm not going to throw out spurious allegations like the ones that have been thrown at me
Ooh,
over the past couple of days
not
that
again.
are absurd.
Extra
But I will
on
say,
the-
Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript, and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness, without us present, may have made the district attorneys and or Your Honor a witness to this in this case, a material witness in this case. And finally, Your Honor, I'm going to ask for, as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, same thing? You want the Harvey? Okay, all right. Okay, Mr.
I think that's messed up. Everybody standing up motioning for a mistrial because your ass was unethical and you hurrying up and denying them. I feel like when somebody requests a mistrial, I don't know if that should specifically only be on that judge. I feel like he should have somebody else to back that decision, to confirm that that is what it is that they want to do. You know what I'm saying? Child, this is a fucking mess. But the dude we just saw, that's another YSL member's manager. Attorney. Shannon Steelwell or something like that, another member of YSL. That's who he's representing. So all of their attorneys are there. So y'all done had a whole sit down with the prosecution, but you got all these damn attorneys here, and they're not made privy of what was going on inside the ex parte meeting with a witness that had been sworn in. Child, this is messy here, honey.
All right.
Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr. Mark Williams Huey.
Okay.
We are also adopting all the arguments that have been made.
All right, sir.
Still by Attorney Adams, by Attorney Matt Sharp, by
I wish he would come to the mic, child.
we also, Your Honor, we were here and when the court did come out, we were not made aware that there had even been an communication that was had, that was on the record, just in the point of just letting the parties know that there had
Can y'all hear him?
I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court decided to argue, and we believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on, even beforehand. I thought that would have been the appropriate move.
Right.
Yes, Your Honor, I'm asking the court for mistrial. I believe that it's appropriate here under these facts and circumstances. Thank you.
All right.
What?
Motion for mistrial denied.
Motion for
Mr.
mistrial
Williams?
denied. I don't think he should be able to do that.
All right. Thank you, madam. Motion's denied. Mr. Gardner?
They
Okay,
all
so
need to
noted.
come together
All
and
right.
remove your ass off the
Okay.
case.
Mr. Steele, last time. Who told you?
None of your fucking business. You done sat up here and went through everybody and then gonna come
All
back
right,
to him
Mr.
like he
Steele's
supposed to tell you
in
something.
custody. Once he clears the area, we'll go ahead and get started.
If by that point we get started, resume the trial, Your Honor.
Yeah, we're going to continue. I'm not calling nothing.
I'm not going to participate in the trial without a steal and without.
You don't have that luxury at this point in time, sir. You don't. You don't.
I don't
You
like
don't have
this
that luxury. You don't have
judge.
that luxury at this point in time. You don't.
Without the court addressing the issue that we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
They need to get him off the case.
Sir, you have to. Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time, sir. Yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would just kind of govern yourself accordingly, sir. I'm telling you.
He's telling you to travel lightly for your ass being contempt too, and you be locked up with your homeboy. Okay, I'm trying to save at least one of y'all. Okay, and I'm really trying to save a nigga. Okay, hello. Look at the court reporter, bitch. I'm hollering at this face. Oh Lord.
As the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was
Girl, this is a
given,
mess here.
said, whatever, this morning. That,
If there is any accuracy to some of the information that we
but sir, I don't even know, your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No,
You're glossing over that. You're
it's
glossing.
not, sir. That's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been. The only
Okay, well then you've made no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Everybody over there with the same face, like you want them. You think telling them that what they learned is nothing of what they learned and then want them to just go with it when they feel uncomfortable with what just happened. I don't like that. Like, just because you the judge, they supposed to go along and just be like, okay, y'all file a complaint.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of situation?
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
He thought he was going to
Williams
tell
does
him
not
something.
wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Oh, wow. But he also wanted to serve his time over there in the same jail that Young Thug will be at so that they can continue to kind of work on the case or whatnot. And it seems like he's only supposed to serve over the weekend. So he has 20 days. So it seems like he may be out free during the week or something. And then he got to report to jail on the weekends. But his wife is trying to get it appealed so that he could be out on bond or whatever during that time before he's supposed to serve. So technically he's not in jail or whatnot. But also, I'm sure him being held in contempt and going into jail could possibly be a strike on his record as a member of the bar. So that's another reason why they probably want to get it appealed. But I feel like the judge was on his high horse just to be throwing around, you know, his power or whatnot. And he wants to focus on how you get this information. And I understand the judge wanting to know that because these are my chambers. How did you get that? Like, that's a violation. But at the same time, you got all these defense attorneys saying that you guys engaged in a conversation that was not supposed to include a witness that had been sworn in. And based on the details that came from that, sounds as though you guys were trying to intimidate him. And that is tactics that we do not use here. And that's in violation, okay? So it seemed like everybody was out here just on some damn violation type stuff, okay? Child, it's all giving sus. But listen, that's all that I got at this time. I thank you guys so much for joining me. Go ahead and like up the video. If you have yet to subscribe to the channel, honey, subscribe to the channel, all right? I'm JamiThatsMe. Follow me on Instagram and Twitter at JamiThatsMe, child. And I'm going to catch y'all in the next one. Bye-bye.
My city and cul-de-sac, coming out swinging like soldier rag, leading my people like quarterback. Boy, I study this shit, I'm an almanac. Had to get up and grind, knowledge is booming, I'm here to apply. Came with the chip and the dip, it just single the mind. We finna do more than survive, I need my check. Spinning the block for the Gouda, we hitting the jeweler, the flood out the net. We don't do beef on computers, I'm straight out the sewer, we come when you rest. Niggas be looking perplexed, so keeping my foot on their neck. No map, I trust my gut for the quest. With drama, I'm fully abreast. I was ready for years and they doubted me. All of a sudden they tell me they proud of me. I've been dropping these haters like calories. Cross them out, I came back with some batteries. Stand for my honor, but you run no corner. Packing the stick with a drummer.